vairākiem gadiem ir apstiprinājusi Latvijas atvērtās zinātnes stratēģiju, kur, protams, arī gan nozīmīga sadaļa ir veltīta atvērtajai piekļuvei. Un šajā stratēģijā virkne punktu ir veltīti tieši tam, lai pēc iespējas visi pētniecības rezultāti, publikācijas, kas top Latvijā, būtu pieejams sabiedrībai brīvā veidā. Tātad attiecībā uz valsts finansētajiem pētniecības rezultātiem, valsts finansētajiem pētniecības programmām jau no 23. gada ir obligāta prasība, ka šīm publikācijām jābūt pieejamām zaļā vai zelta atvērtajā piekļuvē bez embargo perioda. Un arī ir noteikts, ka zinātniskajām institūcijām ir jāievieš atvērtās piekļuvas publicēšanās stimulus un protams, tās izriet no universitāšu stratēģijām. Arī Latvijas Universitāte šogad ir pārskatījusi un atjaunojusi savu atvērtās zinātnes stratēģiju, kurā arī ir noteikts, ka publiski finansēto pētījumu rezultātiem ir jābūt pieejamiem sabiedrībai atvērtā piekļuvē, un arī valsts atvērtās zinātnes stratēģija nosaka, ka pētniekiem ir jācenšas publicēties augstas kvalitātes žurnālos, kas ir atvērtās zinātnes žurnāli, un pēc iespējas jāsaglabā savu publikāciju autora tiesības. Taču mēs zinām, ka praksē tas nevienmēr ir tik vienkārši, jo lai arī apmēram 50%, domāju, katrā universitātē varbūt nedaudz atšķirīgi, Latvijas Universitātē tie ir ap 50% publikāciju, kuras nonāk atvērtās piekļuvas, atvērtajā piekļuvē, vēl joprojām ir spēkā diezgan tāda vēsturiskā senā iesakņojusies paradigma par to, ka žurnāla izdevējs bieži vien nosaka, kas ir un kas nav atļauts, ko viņi atļauj autoram darīt vai nedarīt ar savu publikāciju. Ir izdevēji un žurnāli, kas ir gana atvērti un liberāli un ļoti cenšas sekot līdz atvērtās piekļuvas un atvērtās zinātnes nostādnēm. Ir tādi, kas vēl joprojām nosaka embargo periodu, bet, protams, vēl joprojām nereti arī pētniekiem gadās saskarties ar situācijām, kurās diezgan paradoksāli pētnieks varbūt neiedziļinoties, varbūt īsti neizprotot šos jautājumus līdz galam, ar vieglu roku paraksta līgumu ar izdevēju, un izrādās, ka šajā līgumā ir noteikts, ka visas mantiskās tiesības uz šo te rakstu pāriet no autora uz izdevēju, tātad autortiesību regulējums, protams, to atļauj, bet esam saskārušies arī praksē ar tādām dīvainām situācijām, ka pētnieks pēc raksta publicēšanas šim te publicētajam rakstam pats nemaz vairs nevar piekļūt, jo viņa augstākās izglītības iestāde, zinātnes institūcija nav abonējusi šo konkrēto datubāzi, līdz ar to pētnieks nāk pie bibliotēkas un saka, bet kā es varu piekļūt savai publikācijai, ja jūs viņu neabonējat, mēs sakam, atvainojiet, bet, diemžēl tas nav iespējams. Ja jūs esat šādu līgumu parakstījis, tad, ir tā kā ir. Vienmēr, protams, pētnieka rīcībā paliek preprint versija vai citas darba versijas, bet, tomēr tas nav gluži tas pats, kas publicētais raksts. Līdz ar to situācija ir interesanta, bet ne bezcerīga, un tāpēc mēs esam šodien pieaicinājuši divus ekspertus no Eiropas bibliotēku un zinātnes nozares organizācijas EIFL, Electronic Information for Libraries. Tātad mums ir pievienojusies Milica Ševkušič. I hope I pronounced it right. Oh, yeah, okay. Kas ir EIFL atvērtās piekļuvas programmu projektu koordinātore, un Teresa Hackett, kur ir EIFL autortiesību un bibliotēku programmu vadītāja, kuras mums pastāstīs, padalīsies pieredzē gan kā pētnieki var pēc iespējas tomēr paturēt šīs savas publicēšanās tiesības, gan arī par tādu jaunu salīdzinošu attīstības virzienu, proti jau virknē Eiropas valstu ir nostiprinātas šīs te, angliski sakot, secondary publishing rights, latviski tā būtu atkārtotās publicēšanās tiesības, kas ir, tā kā tās ir likumdošanā nostiprināts, ir stiprākas par līgumiem, kas tiek slēgti ar izdevējiem. Izdevējiem attiecīgi šī te likumdošanā noteiktā tiesība ir jārespektē, un kas piešķir zinātniskās publikācijas autoram tiesības neatkarīgi no līguma ar izdevēju atkārtot, izmantot, atkārtot publicēt šo savu rakstu. Tā kā tās ir divas tēmas, par kurām mēs šodien mēģināsim jums pastāstīt, un ne tikai pastāstīt, bet arī padiskutēt ar jums. Tātad aicinu jūs, mēs dažus jautājumus jau esam saņēmuši reģistrēšanās procesā, un tos arī ekspertiem uzdosim diskusijas noslēgumā, bet visus pārējos jautājumus droši rakstiet iekšā tērzētavā, un tad šos jautājumus diskusiju pēc abām prezentācijām tad nodosim ekspertiem atbildēm. Tā kā droši var rakstīt latviešu valodā, var rakstīt angļu valodā, kā jums ir ērtāk, un tad pēc tam ceru arī uz produktīvu diskusiju. So that was my introduction. Hope you did understand at least a couple of words, for example, EIFL or secondary publishing rights. So let's get started. And I understand we start with Milica, who will talk about how to retain your copyright, some practical steps and advices for researchers. So if you could share your presentation, we are ready to go.
Hello, everyone. Thanks for having us today. Yes, I will talk about some more practical issues relating to rights retention, and Teresa will talk more about large-scale national actions that could be taken. But the general message of our presentation is fully in the context of it's related to the main topic of this year's Open Access Week, and it's about actually having the ownership of your work, of your research, of your infrastructure, of your knowledge. So we will actually be talking about some mechanisms that can help you keep the ownership of your intellectual work. And our message is that that there are mechanisms, but that institutional and even national level support is very important, as you will see from the examples that we will mention. So rights retention, this is where when researchers who publish retain sufficient rights to make their work open access. That's the context for us today. But there are many obstacles to this, and I work a lot with researchers, and I usually see a kind of some kind of fears and misconceptions about sharing their work. And they usually say that they believe that publishers own the copyright, even if there is no copyright agreement. If they haven't signed any agreements, they believe that, and it's incorrect. They believe that publishers own the rights by default. And this is not true. Publishers cannot own the rights if the original author hasn't transferred those rights to them. So this is one of the greatest misconceptions that causes many problems to librarians and also to policymakers. Also, they believe that then when they are signing the copyright agreement with publishers, they believe that they must sign off all of their rights, and that this agreement has to be an exclusive agreement, that after that they cannot do anything with their work. And this is also not true, because there is a way, as you will see, to retain some rights, and it's quite sufficient to give to the publishers only the right to publish the work and to be cited as the first publisher. Even if you give commercial rights to publishers, you can still preserve some rights, retain some rights to make your work open access. They also believe that those copyright transfer agreement terms are not negotiable, so that they have to sign whatever publishers give to them. As you will see, this is not quite true. And they also believe that if they have signed off copyright by signing such an agreement, they cannot share their work at all. And we have many discussions, because if you have a green open access policy and accept them to expect researchers to publish, to make their work author-accepted manuscripts available in a repository, then you have to explain them a lot about copyright and about what they have signed and about policies, etc. So these misconceptions and fears are present, and we have to work with them, we have to live with them, and we have to develop strategies to deal with them. So what's rights retention? I started explaining this. It can mean many things, but in this particular context in scholarly publishing, it means that when entering into a publication agreement, an author is expected to sign a publication agreement with the publisher, the manuscript has been accepted, etc. They can, at this moment, they don't have to sign off all the rights. They can retain copyright in their work. And these can be different levels of copyright. The main purpose of this rights retention is to ensure that the work can be immediately made open access. And in most cases, this is a policy instrument. And it means that researchers, although they could have this right, like by default, they could negotiate this with publishers, they start thinking about the strategy only if they have a policy obligation. For example, if there is an institutional or national policy or funder policy that requires them to retain rights, they will follow this policy and will try to retain their rights. Otherwise, I can say from experience, they very rarely think about this as an option. There are many ways to develop to retain rights, and various methods have been developed over the past 20 years. So here I'm sharing a document where you can find an overview of different approaches. So one of the most famous examples is the offered in 2008 policy at the Harvard University, and then there is a Spark author addendum, etc. So there are many strategies. I won't be explaining them. I won't be even naming them because my focus will be on some practical steps, but you can find a lot in those documents, and Teresa will later share some resources that we have developed in EIFL. How an author can retain rights? Basically, there are two approaches. One is, and this is a more recent one, I would say, when submitting a manuscript, the author adds a statement to the manuscript where the author informs the publisher that there is a source of funding, there is a funder who has an open access policy, and that requires actually the work to be published in open access as the article is submitted to a subscription-based journal, because in those cases usually we apply rights retention mostly. And then they put a statement on the manuscript, and they also put a license with a statement, and this license is irrevocable. This means that this is a kind of a prior license. They have an obligation. This obligation precedes legally the terms of any agreement that they may sign with the publisher. They also put a license on this manuscript, and they also put a license on every subsequent version of the manuscript until it's accepted, and the license remains on the author accepted manuscript. And then when once the manuscript is accepted, they deposit this author accepted manuscript in a repository. It's usually an institutional repository, but can be any other. It depends on the publisher as well. And they put an open license. This is usually CC BY license. It's usually required by research funders and policymakers. And the manuscript is in open access, and it's also immediately in open access, which means that there is no embargo period. There is also an alternative method that's been there for quite a while, and it's like when you go throughout the procedure without putting any statement on the manuscript, but when your manuscript is accepted, the author or the institution, it depends who owns the copyright at that moment, asks for a modification of the publishing agreement. And in this modification actually says that the author retains the rights that are needed to openly share and reuse their work, and then they can put this in the repository. In this approach, there is also a very helpful tool, which is Spark Author Addendum. That is like the phrasing that that you can provide as an author to the publisher. And the logic behind this that if you send an individual request, it's more likely that the publisher would accept this, that you retain the rights and you have these rights. So the moment of the legal precedence or a prior license is crucial to this. You will see later in any disputes, it's very important that you actually have like a legal basis for this. Why it's important? Why is it important? It's important because you actually have the control. If you retain the rights, you have the control, and you can decide how to share your work, and you can share it under an open license. Then, of course, if something is open access, then it's useful for the others. They can reuse it. They can cite your work. It's another benefit, etc. And this is the most important for most of the authors. Then you can publish in journals that are recognized for tenure, and for example, that you score points in the National Research Assessment System, and it's important for your promotion, but then you still comply with the open access policies. Otherwise, you would have to pay APCs, which are not always, the money for this is not always available. And then, of course, what is also very important for most authors is this is a way to comply with the policies of funders and major policymakers, both national and international. I will now cite just 3 examples. One is an international example. This is the Coalition S Rights Retention Strategy. Which is also applied by the European Commission. And I'm citing this example because Coalition S provided really nice resources, very detailed and very simply written, but at the same time very legally founded and very complex about the implementation of rights retention strategy. And they actually elaborate on the phrasing of this statement that is put, we usually call it the rights retention language, that is put on the author accepted manuscript. And this is the first approach that I explained. So you put a statement on the manuscript, you put a license when submitting, then repeat the process. So every version throughout the process of peer review has a license and a statement, and then the author accepted manuscript also has it, and then it's published in a repository. These are the resources that Coalition S has developed. And they are actually guiding authors who have to comply with their requirements throughout the process, from like pre-submission covering letter templates, and they guide them through the communication at every important step with the publishers. So they actually teach you and they give you the ready-made phrasing that you can use when communicating with publishers, because it's very important to know that publishers are trying to make things complicated. They try to reject the manuscript on different bases. Not saying that they are rejecting it only because it's like has this rights retention language, and they're also trying to confuse researchers and to frighten them. So it's like there is a psychological element in this whole process. And that's what makes it complicated. So another example is Leeds Beckett University, and I will be citing 2 examples from the UK, not because their policies are better, but because their actions relating to rights retention are probably the best documented. So we have this information that is of practical value for us, and we can, analyze different steps because Plan S is quite, Coalition S provides different kinds of materials, but we don't have those practical examples. We don't meet them that frequently, and they're quite different. So Leeds Beckett University has a policy. So they had a project that started in 2022, and they adopted 2 policies that address rights retention. Rights retention can be addressed in the open access, open science policy, but it can be addressed in other policies. For example, in their intellectual property policies, also address this issue. And after adopting this policy, they library was put a significant effort to compile a list of publishers with whom the authors from the Lisbeth University published over the past 5 years. And they used Scopus and OpenAlex to compile this list. And after that, they sent a letter to each of those publishers to inform them that rights retention is introduced, and that after the date when they are informed, any article submitted to their journals will be eligible for this policy. So, which means that authors will retain rights and make those manuscripts available once accepted in the institutional policy. And they published the list of those publishers on the website, on the library website. And they also invited researchers, if they're publishing with other publishers, to contact the research services team. And then the research services team contacts those new publishers and updates the list. So that's what the institution does. And this is crucial, this institutional support. At the same time, the authors have to follow the steps that I have already described. So they use the license, the rights retention language, etc. And eventually they upload the manuscript, author-accepted manuscript in the repository, no embargo period, CC BY license. Of course, they were encountering many challenges. So publishers would reject manuscripts that contain this rights retention language. They would refuse to accept the institution's notice, prior notice, and then they would require the authors and the institution to inform them every single time that whenever a manuscript is submitted, it falls under rights retention. And that's quite exhausting, in administrative terms. So it's another way just to discourage the authors and also institutions. And one of the publishers, especially, but also the others, they developed very complicated policies that are quite contradictory. For example, they say that they are not rejecting manuscripts that contain rights retention language automatically, but still the authors cannot use a Creative Commons license, any Creative Commons license, even if an embargo is applied. And also they require authors to agree to this when signing the publishing agreement. And the link at the bottom of the page elaborates on this topic quite nicely, so you can see how they actually deconstruct those policies and explain what's contradicting what's contradictory in them. And also those letters and the policies, they have legal precedence, but many publishers actually require authors to sign in the publishing agreement that publishing terms takes precedence over the other terms. And authors usually, in such situations, tend to pay APCs, to try to find the money to pay APCs or find a different publisher. So they actually get discouraged. Another example of institutional support is the University of Edinburgh, and they are actually a good example to the other universities in the UK, because they really asked for legal advice, and they worked with legal experts, and they actually say that if that they dispute those publishers who introduce restrictive publishing agreements. They claim that their policy has a legal precedence, and they also actually threaten publishers with legal action. And they actually say that they will protect the rights of their authors, and that's crucial for the implementation of rights retention policies. To the best of my knowledge, I'm not aware of any legal actions taken by publishers against the authors or institutions implementing rights retention. It's not impossible that they will try to do this in the future, but currently it's not something that they are doing. So they are mostly trying to threaten authors. So my message here is that the institutional support is crucial in the implementation of rights retention policies. Authors, if they act alone, they can easily be threatened. And now in the next presentation, Teresa will tell you more about not only institutional policies, but about some legal actions that can be taken, legislative actions that can be taken on the national level. Thank you.
Thank you, Milica. So some, I think, really excellent examples. So I guess it sometimes happens that some universities maybe tend to leave it all alone, just put responsibility on researchers. So they adopt a policy and say, well, you are required to publish your articles in open access, but doesn't really give any practical means to implement it. So I think some excellent examples how it can be done from the institutional point of view. So I think we will take the questions later, but then I will give now the floor to Teresa to talk about legislative means and ways who have been developed recently in Europe. So Teresa.
Okay,
please.
Thank you very much. Thanks, Aldous. Thanks, Milica, and thank you very much for the invitation to join you today for this session during International Open Access Week. Margarita, could I ask you please to share my slides? And then I will talk about secondary publication rights. Thank you. Thank you very much. So my name is Teresa Hackett. I manage the program on copyright and libraries at EIFL. And you heard Milica talking about rights retention policies and strategies, and we know that in the Latvian open access strategy document that researchers are encouraged to retain their rights. But we also heard from Milica about the challenges that researchers have when they try to implement their rights. So how can we help researchers addressing these challenges and make their job easier when they're simply trying to publish their research outputs in open access in accordance with national policies and also funder requirements? So next slide, please. So I'm going to talk to you about secondary publication rights, which is a separate concept from rights retention, but is very much complementary. So both of these strategies, both of these issues, rights retention and secondary publication rights, both coexist to support policies towards open science. Next slide, please. So what is a secondary publication right? Well, Milica talked about rights retention policies. A secondary publication right is a legislative measure that tries to ensure that publicly available, publicly funded research can be made available in open access under certain defined conditions that are set out in the law. And what it does is it gives authors the legal right, or their institutions, if the institution holds the copyright, to make a work openly available after or in parallel to publication of a formal version of that work. And that's usually the author's accepted manuscript, or it could be the final typeset version. Now, it's very important that the authors, in order to use this secondary publication right, of course, the authors must, or their institutions must, hold those rights. So that's why it's very important that, first of all, the author or the institution retains their rights, they keep their copyright. And then once they keep their copyright, then this secondary publication right is a way to help them enforce the rights of retaining. Next slide, please. So a secondary publication right means that the author or their institution has the full backing of the law when they're trying to enforce their rights in support of open access. So that they have legislative support, and that it's not then down to individual researchers to try to plead with the publishers or to try to, to discuss more with the publishers. It will be set out in the law. And this will help to ensure that published, publicly available research is openly available and reusable, ideally, even in the absence of an open access publishing agreement with the publisher. So this therefore makes it quite clear that the author can publish their work in open access. And the overall objective is that it helps to increase the impact of published research by guaranteeing dissemination and reuse. Now, I've talked about publicly funded work. So at the moment, secondary publication rights that have been implemented refer to publicly funded work. So that's where the discussions are right now. Next slide, please. Secondary publication right has been described by a number of European academics and scholars who have worked in this area, as described as an effective tool for rebalancing the bargaining power of authors and publishers, enhancing open access to scientific publications, and fostering national open science policies. So it's seen as quite a powerful tool to really make sure and to implement rights retention policies that authors and funding institutions have been seeking to implement for a number of years. Next slide, please. So, and what we can see is that up until now, just slightly over more than a quarter of EU member states have a secondary publication right in their national law. So it's not a particularly new concept in a way, because you can see that the first country to implement secondary publication right in their national law was Germany in 2014. Then we had Austria and the Netherlands in 2015, France in 2016, then Belgium, and most recently Bulgaria and Slovenia. And we'll take a brief look at the examples from Bulgaria and Slovenia as examples of how a secondary publication right has been introduced into their law. So as you can see, with a quarter of member states introducing a secondary publication right, the next question is, will there be a Europe-wide mandate? Because if different member states are introducing secondary publication rights in different laws and in slightly different ways, then there's a broad interest, and there's also a possibility of a Europe-wide mandate. Next slide, please. Next, thank you. So we're going to just look briefly at the two most recent countries that have implemented a secondary publication right. So in 2023, Bulgaria introduced SPR into its copyright law. Now, what I should also say is that you'll have seen from that list that different countries have implemented SPR in different laws. In some cases, it's the law on copyright. In other cases, it's the law on science. It could also be the law on economics or the law on innovation. In this case, Bulgaria decided to put secondary publication right into its law on copyright. So Article 6 of that law sets out that the author of a scientific work, scientific literature, shall retain the right to make that work available to the public in educational or scientific repositories for non-commercial purposes after its acceptance for publication by the publisher. So that's the secondary publication right, a right to publish after the first publication in a scientific journal. Very importantly, in Bulgaria, this right of secondary publication is protected from override by terms and conditions in the license. So in other words, a license, a contract with the publisher cannot take away this right of secondary publication that's been given in the law. And also there's another sort of protection in there where it says explicitly that the publisher may not impose restrictions on the publication of a work only on the grounds that it has already been published in a repository. Of course, the publisher can restrict the work or refuse to publish the work for other reasons, like plagiarism or the quality of the work or whatever, but they cannot reject the work only because it's available in a repository. And I've put a link at the bottom of the slide where you can read more about the Bulgarian Act. The next slide, please. So then, most recently, in May of this year, Slovenia introduced also a secondary publication right. In this case, Slovenia decided to implement the SPR into the law on scientific research and innovation. So there's no right and wrong way to implement SPR. It really depends on the national circumstances and you know, the policy environment as to whether the best place is the copyright law or the best place is under a law on scientific research. And in Slovenia, it provides the legal basis for enabling open access and the reuse of publicly funded research outputs. Now, in the Slovenian law, there is to qualify for a secondary publication right, the work must have at least 50% co-funding with public resources. Now, we would prefer that there should be, that as long as there is any public funding contributing towards that research, that it would qualify for a secondary publication right. But in Slovenia, they decided to go with the 50%. Importantly, it applies to publications and research data. It can be exercised by the author or the researcher, their employer, or by the funder. And like in Bulgaria, any contractual provisions in the license that prevent research from publishing in repositories are null and void. And researchers in Slovenia they believe that this new provision will strengthen the position of researchers to comply with the rights retention obligations that they already have, that it aligns Slovenia's research strategy with the principles of open science, and they believe that it's a significant step towards establishing an open research environment. And I've also put a link at the end where you can read more about the provisions in the Slovenian Act. Next slide, please. So at the European level, there has been some discussion about SPR for a number of years. So since 2021, when the European Research Area Policy Agenda was published for 2022 to 2024, there was an undertaking to have a framework for copyright that's fit for research. And under that policy agenda, the member states undertook to examine SPR provisions that have been enacted by member states. In 2023, the EU Council, so that's the highest political ministerial level, in their conclusions on high quality, open and equitable scholarly publication, they welcomed the introduction of SPR by member states in their national laws, and they encouraged increased knowledge among researchers of the consequences of transferring their copyright from the author to the publisher, and the importance of strategically managing their intellectual property rights to facilitate open access to their scientific publications. Next slide, please. And as a result of these initiatives, there was a report published in 2024, which looked at how to improve access to research and research data for scientific purposes. And in that report, there was a discussion on secondary publication rights with 5 policy options for SPR, which should be to include a broad range of scientific outputs, so not only journal articles, to relax this threshold requirement for public funding to 50% or less, to expand the scope to include the version of record, so to make sure that the version of record is covered by the SPR, to minimize embargo periods, so they recommend no embargo or only a very short period, and to allow all types of uses. And this was to help reduce to help to harmonize the introduction of SPR in European laws, particularly going forward. Next slide, please. So And then most recently in September last month, there was a question written from given by a number of MEPs, some Italian, German and Belgian MEPs, on what actions are the Commission taking to harmonise SPR across Europe. Because of course the Commission is becoming concerned that there is a lack of harmonisation, and that if every country is doing something slightly differently, it'll be fragmented and then won't be workable in practice. So the Commission, in their answer to the question, acknowledged that there were discussions going on. It referenced these studies that I've just mentioned, but it however, gave no firm commitment on its intention to legislate. Well, we can see that with the number of countries that have already legislated and the discussion that is happening on the importance of SPR to implement open science policies, that the discussion, that there will be discussions going in this direction. So we would encourage you now and this week and going into the next months to start this discussion in Latvia, because we anticipate that in some point in the future, that there will, in the near future, that these issues will come into Latvia. And then finally, I'll just very briefly show you a couple of resources that we have. Margarita, if you could move forward. So EIFL has produced a number of resources and guides on rights retention and secondary publication rights. So we have a brochure which is online setting out the principles, the key principles, and links to other resources. Next slide, Margarita. Then we have a page on our website which sets out the issues, what EIFL's position is on the issues, and then a more comprehensive reading list. And then finally, Margarita, next slide, please. Then we have prepared a model provision on SPR in copyright law. So that's if your country is deciding to implement SPR as part of your copyright law, then in the EIFL draft law on copyright, there's an example of some language that you might be able to use to help to implement it. So next slide, please. And that's it. Thank you very much. And Aldous, back to you.
Yes, thank you, Teresa. So I think we have something like 15 minutes for discussion left. So thank you again for wonderful presentations. I know that I will have a couple of questions, but I would like others to have a go at it as well. So you can do it either in chat, as I mentioned, either in Latvian or English. You can also raise your virtual hand if you are willing to speak to us directly, but we can start with a couple of questions which were sent before the event, and I was wondering, Milica, maybe you could answer the first question, which was on use of Creative Commons licenses. You mentioned them in your presentation, but yeah, the question is, do Creative Commons licenses have to be, or can they be attached to research reports? So a somewhat vague question, but maybe you can go a bit into detail.
Any kind of digital content can have a Creative Commons license. So Creative Commons licenses have been developed in a digital context, and they are intended for digital objects. This can be like a digital version of a book. This could be a report. This could be an image. This could be just anything, a research paper. And it's up to the authors, to those who own the rights, to choose the license that they want to choose, or that they are, for example, if it's a research report or it's a research paper, they might have a predetermined license defined by the funder or by the institution. But basically, if you own the rights, you can put a license on the work. And it's very simple. You just put a license and add a link to this license. So yes, the answer is yes, you can license the report.
And I guess you also should. It would be a good idea to clearly indicate what are the options to use the given work. So it really gives a precise instruction for users. So, oh, I cannot use it. I cannot use it just for non-commercial use. So I think it's always a good idea. Right. The second question is regarding moral rights. So, what happens to moral rights, and are they transferable as well? So, I think I can take this question for myself. So, yes, it's actually an excellent question. So, there is a clear differentiation not only in Latvian copyright law, but it actually it goes back to the international agreements on copyright. So there is a clear distinction between moral rights and economic rights. And as elsewhere, also in Latvia, the moral rights cannot be transferred to anyone else during author's life. So that's something that author keeps. They obviously they are quite limited, but they are quite crucial as well. So I think the most well-known moral right is that author always has to be acknowledged. So if somebody cites or uses your work, there always has to be an indication that you are the author. And there is maybe not so widely used right that actually author can recall its work. So even if it's published, you can actually recall and say, I don't want anymore this work to be in publication. So it's really rarely used, but in theory, author has this moral right. But yeah, the important thing is it's non-transferable. So when you sign a contract for your article to be published in a journal, you don't transfer the moral rights. So this is something you always keep. And also after the author's death, it's supposed that the heirs actually also have this right, assumedly for the same time period as economic rights, so which would be 70 years after the author's death. So that would be about moral rights. And the third question we received is it's a tricky one, yeah. So how to correctly use text and or images from my own publication in my doctoral thesis, for example, when compiling a collection of articles. Does this amount to self-plagiarism, and how should this be correctly formatted? So maybe Milice, you can answer this one as well.
Yes. So as for the plagiarism part, because this question I see it as having two parts. For the plagiarism part, this is something that you discuss with your institution and with your PhD advisor, because at some universities, you can actually compile a number of papers already published in journals and, put it together as a PhD thesis. There are such universities. It's generally expected to rely on your results, published results. You have to have a number of published papers in order to be able to defend a PhD thesis. So, of course, you will have to use the results from those papers, try to rephrase as much as possible. And, of course, you can use the images that are already published in your papers. And this is the tricky part that is about copyright. So if you published in open access journals that are under an open license, a Creative Commons license, you won't have to ask for permission because you probably own the rights, and it's even if you don't own the rights, it's under an open license, and you will be able to publish the images. It's only important to cite them properly, to cite the source, to provide the link, or usually a DOI, and also to provide the license and the link to the license. If you signed off your copyrights and published with commercial publishers, usually subscription-based, in a subscription-based journal, you will have to ask permission. So it's not impossible to get this permission. You should check the terms of the agreement that you signed, and also the policies. It's usually written in the journal policies. So we'll find the information there. An increasing number of journals allow PhD students to use the images in their PhD thesis without asking permission. So, for example, they would ask you, if you are publishing a book, they would ask you to have a written permission, to ask them for a written permission. But if you're writing a PhD thesis, they will tell you you don't have to ask permission. But some of them require permission even for this. So you just check the policies, and if permission is required, there is usually a form on the journal website, and it's usually they outsource the a company, a commercial company, to manage this, right? It's rights link, and you are just guided through the process. It's quite easy, and you precisely say the purpose. It is in a PhD thesis that is expected then and then, and you will usually get the permission practically in a minute. So it's not difficult. Sometimes if the publisher doesn't have this form, you will have to write a letter to ask for this permission, but in 99% of cases, you will get a permission to publish your own images. So for the plagiarism part, you have to consult your institution, and for the copyright part, you can do this, but you need a permission and you need to credit the original source and the license properly.
Thank you. Yeah, and I might add that doctoral thesis is really an interesting case because, yeah, normally you probably, if you are using your own publications in your own research, then it should be fine. But then again, doctoral thesis by the Latvian law, at least, they have to be published. They have to be publicly available. So that's kind of borderline situation. So I think to be on the safe side, it is probably a good idea to check with the publisher. And as you described, it's not that difficult. So we have one more question now in the chat. So what trends can currently be observed regarding the accessibility of sources used in research? For example, the opening and sharing of datasets, images, or archival materials. Who would be keen to answer this one?
I think Milica would be the best person to take this one too.
Yes,
if that's okay.
So for publications, it's like easy. You have a policy, and we know all about it, how to share. As for data sets, we usually say to researchers that they have to comply with the FAIR principles. So data sets don't really have to be open. If there is a reason why they shouldn't be open, but they need to be FAIR compliant, which means that the data sets should be deposited, those stemming from research should be deposited in a repository. The metadata should always be available. The data may not be available. There are various situations when this is not possible or reasonable. There should be a license, a machine readable license, and that's how we handle this. So in practical terms, if you have a policy, for example, in Serbia, we have a national policy, and we require researchers to make the data that are underlying publications publicly available, which means those data have already been published in publication. They are just more detailed. And if they are properly anonymized, etc., there are no sensitive data there. They should be required to make this data publicly available. Also, it matters what's written in the DMP. So if you have a data management plan, you define in the data management plan what will be open, what won't be open. So it's like you just follow this, and data management plan should be reviewed by someone in the project. So that's a general trend. And as for images and archival materials, this falls more into the heritage sector. So it often depends on the resources. It's not so much institutional policies. For archival materials, you have legislation. So sometimes, for example, the national legislations puts an embargo on some materials, so you have to follow those embargoes. And as for images, it depends. I couldn't say more because it also depends on the institutions. And most institutions, for example, museums, they would like to make some images available, but sometimes they don't have the resources to digitize them properly. So this can also be a limitation. There is also one thing that is relating to images, and it's also related to copyright. It's called the right of panorama. Teresa, am I right? I usually use the wrong name of this, which means that in some countries you have like historical buildings, you have sculptures in the public space, you have images, paintings in the museum, etc. And in some countries, if they don't have this right of panorama. You can't make the images taken in the public space available under an open license. And I will tell you an example from my experience. So, for example, I took some photos of the new building of the Greek National Library, and Wikipedia, and I put them on Wikimedia Commons for people to be able to see. And after some time, there was a campaign to delete all the images of this building because it's the architect is still alive, and it's like the work is copyrighted, and Greece doesn't have this clause in the legislation. So if you want to make images taken in public space available in open access, you will have to check national legislation, and that's quite tricky because we are not like trained to think about it. We think these are our photos, we can share them. So there are many details that you should take care when you're making images available. As for research images, if you are a creator of, I don't know, a diagram, etc., then it's the same as with the articles. As long as you own the rights, you can make those images available. And we often encourage researchers, because they usually make only those images that are taken that are published in research papers. They make them available, but they usually have, microscopic images. They have a lot of them that they never publish, and we encourage them to treat those images as research data and to make them available in a repository under an open license, because those images can be useful for the others as well.
Thank you for the detailed answer. I can just add that sometime during this week, I'm not sure on which day, but we'll also have a webinar on the new Latvian national open data repository, Dataverse, which is currently being implemented not only in University of Latvia, but also in other biggest universities. So everybody is welcome to attend also this one. I think it's a huge, really way overdue development in Latvia, so we're happy to have it, and we hope that researchers will use it more and more. As for accessibility of images and archival materials, so yeah, I think it's getting better all the time. So the institutions, not only in Latvia but across Europe, are publishing on more and more data which can be used for research and quite openly. Obviously, there are sometimes issues that the archives and museums want money for that. So obviously, it costs them to produce those images. So it's kind of understandable that they want to reimburse, somehow get back those expenses, which is also the case in University of Latvia. So we ask for a small, moderate fee for if somebody wants to use our historic images, for example, in commercial publication, then we certainly will ask some money. In research, not so much. So if it's just for research purposes, then we might look at it a bit more favorably. I think we will run out of time, but just a quick question about to Teresa. So Milica is answering all the questions so far, but Teresa, I wanted to ask, so you mentioned that a number of European countries have implemented this secondary publishing rights. So I was wondering if publishers have challenged this concept very heavily. For example, I was thinking that they might argue that the licenses they are signing should be viewed in light of the country where they reside, not the country where researcher resides. So the legislation, for example, of United Kingdom should be, used in signing the license, and also have there been such cases?
Well, thank you. I mean, there has been, or there is, and of course there has been resistance in some countries to some of these provisions. I think what's been, I think the important thing is when you're signing a license that you would try to ensure that the governing law of that license is the governing law of your own country, so that then you know what your law says and you know how to apply your law to that country. I know that's not always easy, but I think if you have a provision in your national law that says that no term in a license can override what your national law says. It could be helpful in making your case if there is ever a challenge. I'm not aware of any challenges to the secondary publication rights in countries, but I think as the laws are being developed, then there are, of course, challenges to how broad the provisions might be and so on. And that's why I think it's important for us and for researchers that the European Commission steps in, that there is some sort of a European wide mandate that tries to create a level playing field for researchers all over Europe. And then we try to avoid this kind of question about jurisdiction, and a little bit like the way the DSM directive has put a mandate on, that there are certain exceptions that are mandatory and that these exceptions cannot be overridden by contract on a Europe-wide basis. And then I think the other thing that's kind of interesting is we can see that in some countries, as I mentioned, this secondary publication right is put into the copyright law, but in other countries, it's put into the law on open science or the law on innovation. And in some environments, that may be an easier way to frame it. So then you sort of remove it from the copyright debates, which we know can be fraught and difficult sometimes. So if it's framed within the policy on open science and open access, and then implemented through the law on open science, then that also makes it a little bit easier in terms of implementation.
Yeah. Thank you. I really hope that this discussion also will help to kickstart the discussion on secondary publishing right also in Latvia. I know I personally reach out to my contacts both in the Ministry of Culture and Ministry of Education. I'm not sure if anybody is attending, but we will certainly follow up after this discussion. I hope that the presentations also will be made available and we can send them both to the attendees, but also reuse if we, for example, go to the Ministry of Education, right?
Sure. Of course, and we'd be glad to provide any more information or any more analysis that would help you in these discussions, because I think for sure the discussions will be coming to Latvia. Yeah,
I really do hope so, because my feeling is that this would definitely help. So as far as you rely only on researchers and or institutions, it goes just that far. But if you have it in national legislation, then it makes things much easier for everybody. So I think it would be really an important and useful step towards implementing national open science policy as well.